Disparate impact theory came from the seminal case of Griggs versus Duke Power, the 1971 case, where a job requirement was put into place that had a disproportionate effect on black workers. It was originally intended as a mechanism to smoke out intentional discrimination where you had a facially neutral policy. But in practice, it has devolved in large measure into simple quotas. The metastasization of the administrative state, I think, is driven in not insignificant part by the disparate impact theory's evolution, probably far beyond what the Supreme Court had originally intended. But what we've seen is, I think, the administrative state has imposed disparate impact theory in many regards in an unconstitutional, or at least arguably unconstitutional fashion. Because you can't classify on the basis of race or accord benefits and detriments on the basis of race, but when you simply impose on employers or school officials a requirement that they get their numbers right, in other words, there is a proportional representation of each group, guess what? Each practice and test is going to have a disparate impact. And so you have this kind of soft discrimination, which hurts everybody. It makes race, sex, and every other category that much more, we pay more attention to those factors than we otherwise would, but we are actually discriminating on the basis of race, sex, and a whole host of other protected classifications. That's not the way society should be constructed. That is against the law. It's against the Constitution.